Well, hello, everybody. It is another Saturday, and I am Dennis Block bringing you another edition of Zoom Landlord-Tenant Talk Radio. Always enjoy doing this every Saturday at 3 p.m. I did want to talk about what's going on with regard to the city of Los Angeles today, and also with regard to selling a single family home. When you're selling a single family home, if you have a tenant in possession, you're going to have an issue trying to sell that house, because in most situations, a single family home would not be under any kind of rent control or eviction protection. All you'd have to do would be to serve your tenant with a 60-day notice, presumably if they're on a month-to-month tenancy and have been there longer than 1 year. And by doing so, the tenant would have to vacate. You'd get the place prepped and ready to go with regard to selling the property. But you see, the people who run our city have now made it almost impossible to do so, making it impossible to even sell your own single family home. Because now every residential property in the city of Los Angeles is now under eviction protection. So for a single family home, you can raise the rent, but you can't ask a tenant to leave unless you have good cause. Well, of course, good cause could be, for example, damaging the property or violations of the rental agreement, or even, failure to pay rent. But curiously, what is not a reason to evict is that I want to sell. So how is it that any landlord with a tenant in possession of their single family home is going to be able to sell it? Obviously, the buyer is going to want to move in, and obviously he's going to want to have a vacant home to move in. So how is that possible? Now, of course, if the seller would want to try to state that, well, the new buyer is going to move in, he's not able to do that. So he's going to have to allow the seller, once he becomes the owner, to move forward with regard to stating to the city, hey, I want to move into my own home, and filing those things that need to be done. But you see, most buyers aren't going to want to go through that. If you're not going to be able to deliver a vacant house to them, then how are you going to sell your house? You're not going to be able to. So the city of Los Angeles has put this roadblock on that really is truly difficult and makes it very hard for landlords to sell their single family homes. There are two solutions to the problem. And of course, they're indirect solutions, but there's two solutions to the problem if you want to sell your home with a tenant occupied. One is, nothing prevents you from raising the rent. So you can serve a rent increase that might have the effect of forcing that tenant out. If you are going to raise the rent more than 10%, you'd have to serve a 90-day notice. So that's one plan to make this tenant move. The other way would be to agree to do a major renovation to your house. Major renovation is defined as work taking longer than 30 days where the place will be uninhabitable for that period of time. And it also requires that you obtain a building permit, like an electrical or plumbing permit, if you're going to redo a kitchen or a bathroom or both. So the city of Los Angeles requires that you first obtain those permits, and that you also have a contractor give you an itemization of the scope of the work, showing that it'll take longer than 30 days to complete. So by doing so, we can then apply to the city. we have to pay the tenant relocation, which in this case would only be 1 month's rent, and then we could force the tenant out. But the reality is, if you're not intending to do a major renovation to the property, then you're somewhat stuck with regard to the possibility of having that tenant to move. So you're kind of just stuck with either raising his rents or possibly trying to do a voluntary vacate with the tenant, offering him some money to move. Anyway, that's my topic for today. We're going to open this up to questions. We're going to go in order. Please, if you want to be called upon, please raise your hand electronically. That's on the bottom of your screen where all those icons are. And I will call on you. I will ask that if I'm not talking to you, make sure that you are muted at all times. We will try to get through everybody that I possibly can in here. I see there are a lot of questions already going. So let's start with Audrey Smith. I'm going to ask you to unmute yourself. And Audrey, are you there?
Yes.
Hello, Audrey.
Hello?
Hi, can you hear me?
Yes, I can. And thank you so much. My question is about a tenant that has an old car that doesn't work and a lot of debris is under the car. It could be a hiding place for pests. Been there 5 or 8 to 8 years and it hasn't moved. So my question is, how can I get the...
Oh, I lost you there, darling. Let's see. Try to unmute yourself again, please.
Okay.
There you go.
Okay.
So first of all, what city?
LA.
Okay. And is this an apartment or a house?
It's an apartment and a carport.
Okay. And does your tenant have a rental agreement?
Yes.
Okay. Usually in most rental agreements, it states that you cannot have an inoperable car parked on your property. So if that's contained in your rental agreement, you could serve your tenant with a 3-day notice to either move the inoperable car or tell them to fix it within the 3 days so it's operational. Now, if your rental agreement doesn't have that phrase, you're still in luck because the city of Los Angeles prohibits having exposed inoperable cars on your premises. If it's in a closed garage, it's okay, but you have a carport. So the city of Los Angeles would say that would be a violation of the city law. So in either case, whether it's in your contract or not, we could serve on your tenant a 3-day notice to either move the car or make it operational within the 3 days. And when they don't, we now have the right to ask this tenant to move. Hopefully that answered your question, Aubrey.
Thank you so much.
You take care.
Okay.
We are now going to move on to, let's move on to Dina. Dina, I'm going to ask you to unmute yourself.
Yeah, hi, Dennis. Many thanks for your support and for these wonderful Zooms that you're doing. Much appreciated. I have 2 questions. It's in regard of my tenant upon giving me the 30-day notice of intent to vacate. He gave it to me on the 15th of November to vacate on the 16th of December. So after that, I sent him, an email asking him to be on the same page and to remember his obligation that he has to continue to pay me rent. And once I rent the property, I will return back immediately whatever rent he paid me after the date of re-renting the property, and to give me his new address so I can send him the deposit, the security deposit remainder or something. He ignored the email. But later at the end of November, he paid me the rent for December. So my first question, the due date for returning the security will be on the 7th of January. If he again, at the end of December, pay me the rent for January, can I also, as a precautionary act, deduct from the security deposit the rent for February, or just to be on the safe side, or I can't do that?
Has your tenant vacated?
No, not yet.
Okay, when does your tenant say he's going to vacate?
On the 16th of December, so on the 7th of January, it will be 21 days. Within this, I have to send him the remainder.
Right. And the answer to your question is you can deduct for the remaining term of the lease immediately. So in other words, you're not going to give them any money back, but on the security deposit itemization, for example, you're going to
Yes.
write the security deposit was $1,000
Yes.
and that you owe me $5,000 until the end of the lease term. Therefore, the balance owed is $4,000. And if in fact, I would put a little note there, if I do rent it out quicker, then the amount that you owe me will be lessened to the date that I do re-rent it to somebody else.
I see. And would he still be obligated every month to pay rent at this point, or because I tell him, okay, I deduct the
Yeah, no, he is liable to pay you the rent every single month.
I see. And the second question, Dennis, on my contract with him or the lease agreement, there is something about the early termination or breach of contract that the tenant would be paying also. One of the things among things like even if you want to touch up paint the property or like paint it, but the first thing is the commission for the real estate agent. Would that hold legally, or it's in the lease though? Very clearly.
Okay. If you need an agent to lease your property for you, then the commission can be deducted from the security deposit. But in addition, well, actually, I wouldn't say from the security deposit, but the tenant is liable for the commission as well, because obviously that's a cost of re-renting it. So while you can't deduct that from the security deposit, you can only deduct rent, cleaning, and unusual wear and tear. The ultimate amount of money that the tenant owes you would be also contained in the at the end of the lease contract, which is until that time is expired. So if in fact you have a tenant who moves in let's say 1 month, so his liability, your previous tenant's liability would be lessened, but still you can still deduct for the commission.
And is it like I can write it on the security deposit also with the other items, like you're going to be liable for the
Well,
commission of my real estate?
You can still write that, but again, you're only allowed to deduct for unusual wear and tear, cleaning, and any other rent owed. Okay.
I see. Okay. Thank you so
I'm going to ask you to mute yourself if you'd be so kind.
Of course. Thank you.
And we're going to move now over to Kay Benz. Kay Benz, if you will unmute yourself.
Yes, I'm unmuted.
Thank you.
Yes, a friend of mine said that she lost her case in court because they said she didn't have a property description. I thought the address is the property description. Do you know what's meant by the property description?
No clue, because I have no clue, because what the property description is exactly the address of the property. Now, maybe she didn't do it. Maybe she didn't do it fully, like she didn't put street or avenue. Maybe she didn't list the apartment number, and that would cause you to lose. But if you're listing the correct street number, the street, the address suffix, which means street, drive, etc., and the city, I think you're fine. So I can't comment on that. Okay.
One other question: if you are a member of the apartment association, can you take advantage of this Zoom?
Not sure I understand that question. Anybody in terms of this Zoom can always join our meetings every 3 o'clock on Saturday. In fact, I think I'm going to be doing a special Las Vegas edition next Saturday, because I'll be in Las Vegas, so you might see a different background, but I am going to be doing it then.
Oh, okay, thank you.
All right, thank you, Kay. Okay, let's move on. I'm going to move on to, I'm actually looking for a special mystery guest that I don't see here. Oh, I think I do see it. Maybe it's RBN. I don't know. Anyway, if my special mystery guest, please raise your hand so I can find out who you are, so I can call on you. But notwithstanding that, let's move up to Ryan Fitzgerald. I'm going to ask you to unmute yourself.
Hey, Dennis, how are you today?
I'm good, thank you.
Thanks again for all your help and all your answering of the questions. So I had a question. I filed to evict a tenant, and then I finally got a hold of somebody at the city, and they said that they just had to make sure that the notice that I gave the tenant to vacate in 60 days was the proper thing, but the proper way, but they wouldn't tell me what it was. Can you tell me what's required for a proper notice to vacate?
What city is your property?
In Los Angeles.
An apartment or a house?
It's a duplex.
Okay, and with the duplex was built in before 1979?
Yes.
So you're under, obviously, the LA rent stabilization ordinance. Why did you issue a 60-day notice?
Because I have to move back into the property.
Okay, so if you first have to get the application process with the city, did you do that?
I did all that. And so when I talked to the representative yesterday, he said, we just have to verify that the letter that you gave the tenant to vacate is properly done or meets all the requirements. And I was like, well, tell me what they are.
Did he say that yours didn't?
He wouldn't say yes or no. He said,
Well,
I can't give you any legal advice.
Submit it to him. Okay. I mean,
I
don't recommend.
already submitted it. I just want to know what that letter has to say.
Well, there's many requirements that have to go into that, so it's kind of difficult without. I could, if you want to call the office, then I could review your notice, but I can't do it in a situation like that. You basically have to obviously have the tenants' names. It has to say 60 days. You have to explain about the relocation money that has to be given to him. You have to state the reasons. You have to have that application process attached to the form. So
I did all that.
Again, I can't answer it any more than that, my friend.
Do you have any forms on your site that would
No,
be
this is a billable event from my law firm. So we charge our clients to prepare these documents.
So you don't have any like free landlord documents?
I don't. I have
the vacate letter.
We have a 60-day notice for like non-rent control. Anyway, thank you, Ryan. I'm going to mute you now, and we're going to move over to, let's go to Karen Kurahari. I'm going to ask you to unmute yourself.
Hi, Dennis. Thank
Hello,
you.
darling.
LA RSO owner-occupied fourplex, problem tenant on a 1-year lease, only been in the unit 5 months. And I've been, we did the 24-hour notice. You helped me out with that. I'm on like every Saturday. So now we're down to non-payment of rent. As he has until the 5th. As of December 6th, he will be considered late if it hasn't been paid. So at that time,
Well, let me stop you there. Is rent payable on the 1st or is rent payable on the 5th?
rent is payable on the 5th, but considered late after the 5th of the month.
I think you said it wrong. On the rental agreement, does it say the rent is due on the 1st of each month?
Yes.
Okay, so you can serve a notice today. You don't have to wait to the 5th. By waiting to the 5th just means when your late charge is going to get kicked in. Okay, so you could serve it right now today. If you serve it today, the tenant's going to have until Wednesday midnight to pay the rent. And if he doesn't pay it by Wednesday midnight, we can start the case on Thursday. So what I would do is, as soon as this Zoom meeting is over, get up. You can go to my website. You can fill out one of those 3-day notices right there. You can fill it out on the screen at evict123.com. And that's a no charge notice, and then go serve it. And then we can start the case if you're not the full rent in your hand by by Wednesday midnight. Now, let me ask this as I'm thinking about it. How much is the rent per month?
Oh, he's above the threshold. It's
Okay, that was going to be my
23.50.
question. Yeah, you have to be
Yes.
above the threshold. All right,
Yes.
Karen, thank you. I'm going to mute you. We're going to move along. And let's take Christopher Rouse. How are you, sir? Christopher Rouse, please unmute yourself. Going on, my friends. Okay, I guess you weren't ready. We're going to move on to our trombonist, Dennis. How are you, Dennis? Please unmute yourself.
I am unmuted. Thank you very much.
And how are you, sir?
I'm just doing fine. Again, I'm from Riverside County, and I would like to, if I may, give a series of questions that you can say yes, no to. These are pre-screening questions, okay? So I get the telephone call, and I say, thank you very much for your interest in my unit. This phone call is being recorded for quality assurance. May I first ask your name, and in case we get disconnected, may I have your telephone number? Blah, blah, blah. Okay, fine. The next question would be, well, why are you moving? Can you tell me about that? And then how many people will be living in the unit? May I ask what your source of income is? And may I ask what the income is about? And then I have to say, what is the I would have to tell them what the threshold is. So they either meet the threshold or don't. Do you have any felonies? Do you have any evictions? Those are my questions. Any problem with those?
No, I like that. This way, if in fact they tell you, for example, how many people are going to be moving into my unit? Oh, we have a family of 16. Well, I'm sorry. This is a 2-bedroom unit. We allow 5 people to move in. You're above that amount. So on that basis, you don't have to even fill out an application because I'm not letting you in. So those are really good questions. I did a video for the Apartment Owners Association. You can go to their video lists and you'll see it. And I said basically the same things that you're saying right now.
Well, question mark. What is the threshold for a 1-bedroom or 2-bedroom?
Well, fair housing, which I like to call unfair housing, states it's 2 per bedroom plus 1. So therefore, for a 1-bedroom, that would be 3 people. For a 2-bedroom, that would be 5 people. Now, for a single, you can have it limited to 1 person. And I'll ask you, Dennis, do you know why?
Well, for one, I understand that, for instance, if you have children of opposite sex, they have to have separate bedrooms. And therefore, if you have people of the same sex, that's not a problem.
Well, that's not the reason why you can't limit a single to a 1-bedroom. I mean, to one person.
Wait a minute. Are you saying? Well, okay.
A landlord cannot. I'll give you the answer. A landlord cannot limit a single to 1 person, because then you would be discriminating on the basis of children. Because you see, a child can't move into your unit by itself. So therefore, it would be like a mother and a child or a father and a child. So if you said I'm limiting singles to only 1 person, you're actually discriminating on the basis of children.
Right.
So anyway, thank you very much. I'm going to mute you. We are going to move on, and we're going to hit the next one in line. I see a David Brooks. Mr. David Brooks, would you please unmute yourself?
Hi there, Dennis.
Hello.
Okay, quick question. I'm an agent. I'm representing a buyer that's considering purchasing a 4-plex in LA RSO. We've got no rent. There's currently 3 tenants, longtime tenants. The seller inherited the property. They have no lease agreements, and apparently they're not providing estoppels. So my buyer wants to move into one of the units and also move his 22-year-old son into another unit. So he's looking at evicting 2 of the 3 remaining tenants, and he wants to know roughly what he might be looking at. I've looked at the relocation expenses. I believe he qualifies as a mom and pop landlord, I believe. So I think it's around 20 grand per tenant if they cooperate. But he's asking, look, what am I looking at, best case or worst case scenario? Because it looks like a few of the tenants aren't going to cooperate. They're telling us, oh, we're not moving. So that might be a problem.
Okay, we are talking about the city of Los Angeles, correct?
Yes, sir. Yes, sir.
Okay, number one, this type of tenant is exempt from being asked to move if you want to have yourself or a family member move in. If the tenant has lived there longer than 10 years and is 62 years of age or older, that tenant is exempt. That's number
Okay,
one.
not the
Number
case there.
two, the law requires, do they all have the same amount of bedrooms?
No, one is a 2-bedroom and the other 3 are 1-bedroom units.
Okay, so technically you have to take the last tenant in is the first tenant out for that size unit. So for example, for the 1-bedrooms, you couldn't take the oldest tenant who's been there, who's obviously paying less rent than the newest tenant who moved into the 1-bedroom.
Okay.
You'd have to take the newest tenant, so that's one requirement. The other one is for the 2-bedroom, you could just take the 2-bedroom. There'd be no problem with that because there's only one 2-bedroom on the property. But again, you would have to pay relocation. You got to go through an application process with the city. Is this doable? And the answer is absolutely. We do these all the time. So you might want to suggest to have your client give us a call once he becomes the owner of the property. We can't do anything prior to that, though.
Gotcha. And absent any lease agreements, which the seller doesn't have since they inherited this property and they have sloppy records. There's no lease agreements and they won't sign estoppels apparently. What is my client in for if he does decide to buy this property?
The seller of the property has to make a list, which he warrants that this information is true, that this is what the names of the tenants are and this is what they're paying rent. And you might also ask him to show proof that how the tenant is paid rent, like show me a copy of a check that the tenant has offered in the last couple of months. So this way you can establish exactly what the rent is. The tenant estoppel is nice. I mean, it's not a cure-all, quite frankly. It's nice to have a rental agreement, but if what he's attempting to do is just merely move in, I don't see a problem with that as long as it meets the criteria that I just talked about.
Best case scenario, roughly 20 grand per tenant if they cooperate. Worst case scenario, we're looking at an unlawful detainer.
It's not 20 grand. I think the relocation for mom and pops is about 8,500 that you can do, though it does go up to a total of 24,000, but I think it's around 8,800, 8,500 for the mom, if you get the mom and pop exception, which, by the way, everybody who doesn't know what we're talking about, the mom and pop exception means that an owner has 4 or less units in the city of Los Angeles, and they can also have a single family home. But so then the relocation is less because you qualify as, quote, a mom and pop owner. Anyway, thank you. Go ahead, David.
Okay. And if they don't cooperate, he's got to do an unlawful detainer, which I assume can get pretty expensive.
No, our fees are relatively inexpensive. So, but there's no problem getting these people out as long as the owner and his close family member, which is either a grandparent, parent, yourself, your spouse, your child, or your grandchildren, are moving in. By the way, they have to stay there for 2 years. And when they move out, you cannot raise the rent to market value. You'd have to charge the same amount of rent as what these current tenants were paying, plus any applicable increases that the city would allow.
Gotcha. Dennis, thank you.
Hey, you have a good day, sir. Thanks for meeting us.
All right.
Okay, I'm going to move on to, let's move on to Suzette. I see you here. I'm going to ask you to unmute yourself, young lady.
Hello, can you hear me?
I hear you wonderfully.
Yay, I got through finally. Hi, Dennis.
Hello, darling.
I'm in the unincorporated county of LA. I own a duplex and I live on one side and I rent the other side out. I don't meet the threshold. I just started listening to your podcast and I learned about this threshold thing. The tenant is always late and I don't meet the threshold, so I have to wait 2 months to evict. So we're in the month of December. She has not paid. Her rent is due on the 1st. My question is, I know that now the county of LA, you have to serve a 10-day notice. So if she pays me on the 11th day, can I refuse that rent and then wait until January
Okay,
in order to serve that 10-day notice on her?
okay, let's take a deep breath and let's correct some things, but let's also explain to the audience what we're talking about.
Okay.
The city of Los Angeles and unincorporated areas of LA County require that you cannot serve a 3-day notice to pay rent unless it's above the threshold. The threshold for a 1-bedroom is 1747. The threshold for a 2-bedroom is 2222. The threshold for a 3-bedroom is 2888. Now, so that means let's take the example of a 1-bedroom, 1747. If my rent is $1,600 and you don't pay me in the month of December, I can't serve you by the morons who run the city of Los Angeles, or the supervisors, equally being morons who run the county of Los Angeles, unless the 3-day notice exceeds 1747. So on that basis, I would have to wait until January. So where at 2 times 1,600, the rent would be 3,200. That would now be above the threshold. But as you're saying right now, Suzette, what if the tenant comes to me on the 25th of every month and pays me the rent? What can I do? And the answer is nothing, because if they pay you the full amount of rent that's currently owed, you have to accept it. But if you get, for example, to January 1st, okay, New Year's Day, if he comes over with the December's rent, you could say, no, I'm not accepting it because you owe me 2 months rent now. But what the city and the unincorporated areas of LA County have done is they've created a situation where every tenant can pay their rent 25 days late. Now, for you landlords out there listening, don't take a partial payment if you're in the city of Los Angeles or unincorporated areas of LA County, because by taking a partial payment, let's pretend that the rent's $2,300 and he gives you $600. Well, now you're going to be below the threshold because your 3-day notice will be, what about $1,700, and you're below the threshold. So don't take a partial payment. But I feel your pain. I've been talking about this since the city and the county came up with this. This threshold amount is insanity. And also, if you have a Section 8 tenant, that's really insane, because if the rent's $2,000 for this 1-bedroom, we all know that the Section 8 will pay approximately $1,800, and the tenant only share is $200. So on that basis, you'd have to wait 9 months until the tenant owes you $1,800 and their share before you could even serve a 3-day notice. So it's insanity for Section 8 tenants. You can't kick them out for non-payment of their share of the rent. Anyway,
But in my case, my understanding was it has to be a 10-day notice.
Yeah,
to
and
pay
your
rent.
understanding, my love, is wrong. A 10-day notice is only for a notice to perform or quit, having nothing to do with a notice to pay rent or quit. For a notice to
Oh.
pay rent or quit, it's a 3-day notice. However, you have 5 days from when the tenant was served to send to the county a copy of your 3-day notice and the proof of service. You have 5 days from when it's served. Thank you very much, Suzanne. We are on the move here. And since we're on the move, what we're going to do is we're going to ask Rising Sun to unmute yourself. Rising Sun, there you go.
Hi, Dennis.
Hello.
Okay, so I have a question regarding to the rent increase. So one of my tenants sent me a letter long, like many pages, and then telling me that I need to return like the rent rollback. He said that they're based on in Pasadena, there's a charter amendment that based on that charter amendment, I need to return the rent increase that I have starting on January 2023. And then The base rent is at 2021, March 7.
Yeah, I don't
7.
want to go into the details, but let me just
Okay,
give you
so-
the overview because
Yeah.
I'd have to
So
have a
do I need to
calculator
refund
sitting
the
in.
rent?
Yeah, let me just
Okay.
explain what you're trying to state.
Yeah,
They passed Measure H in Pasadena. It was on the ballot. And in fact, if you look at the statute, right at the beginning of the statute, subsection 1, they quote my name in the statute saying that I encourage landlords to raise their rents while they could. This was a couple of years ago. So they used me as justification as to why to have this statute. Well, of course, everybody who listened to me and raised their rents were okay. Rent control is going to hit every jurisdiction, so you need to raise your rent. But they did quote me in that statute. And I don't have the specifics in front of me, but I think what they said was any rent increase that you had done that took effect in, I think the year was March of 2021, then you had to roll back your rents to what the base rent was at the time, and then you were entitled to a 7% rent increase. But if you didn't roll back your rents, then from when that statute passed, technically that's a credit owed to the tenants, and you do have to give them back their money. I can't take the time now to get into the specifics of exactly when you were taking rent and when you weren't, but the law does state that once that measure passed, your rent was rolled back to what it was as of March of 2021, and then you were entitled at the time a 7% rent increase from that point forward. And now I think they're making a quote rent commission, which they will now tell you what the newest rent increase is. But to get into more specifics, I would suggest just call my office and I can go over that with you.
okay.
Thank you for joining our meeting today. I am going to mute you and let's move on to Al. Al, please unmute yourself and I'm happy to talk to you. Oh, by the way, before we go forward, I'm going to try to get to everybody, but I am walking out the door at 4 o'clock today as soon as this is over because I am racing to a Laker game that's happening tonight, and I hope the Clippers lost today. But in any event, Al, are you there?
Yes, yes. How are you, Dennis?
I am fine, Al.
Okay, I have a single family home in West Hills, and before the tenant moved in, the lawn was all green, and now it's pretty much dead, and even parts of it are dirt. And I have it written in the lease that they must water the lawn, but I reminded them like several times, and they don't seem to do anything about it and don't care.
Well, first of all, they probably don't care because they don't want to spend the water, pay for the water to water the lawn. Do you have it on automatic sprinklers?
There is automatic sprinklers, but they don't use them.
Well, automatic sprinklers.
I know they have it turned off, is what I'm trying to say.
So they've intentionally turned it off.
Yeah.
Okay. Well, you can tell them that that was their responsibility to keep the lawn up, and that they're now liable for the cost for reseeding, and that you're going to hold them responsible. Either you can take that from their security deposit, or you could tell them that you're going to do it now and send them a bill. And if they don't pay the bill, that would be grounds for eviction.
Oh, so I just sent them like a formal bill?
Yeah, I want to take a look at your rental agreement that basically says any damage done to the property is the tenant's responsibility to pay for it. Most rental agreements have a phrase like that in there. So I would send them a letter now telling them, look, you've killed my grass. I'm asking you to replant it and leave the automatic sprinklers on. If you choose not to, then I'm going to do it myself and hold you responsible for the cost.
Oh, then send them a bill. And then
send them a bill. If they don't pay the bill, then I know this eviction attorney that would be happy to help you.
Okay.
So that's enough.
All right,
Actually,
we're going to move.
I just want to tell you I'm actually using your lease that I got.
Oh, well, I can tell you it's in that lease. So
Okay.
anyway, we're going to try to get through as many as we can. So thank you, Al. And now we're going to move on to Julia Jordan. Julia Jordan, how are you?
I'm great, Dennis. How are you?
Can't
Thank you so much.
complain.
All right. And like everybody said, and I feel the same, thank you so much for doing this. We really appreciate all your help and support and guidance because I really need it. But I'm following up. I did attend your 3-day notice seminar not too long ago and how to properly fill out a 3-day to pay or quit notice.
Mhm.
And one of my questions, I have a couple if you don't mind. One of my questions real quick is, on here, it says that the payment may be made anytime within Monday through Saturday, 8:30 a.m. to 5:30 p.m. Can I revise that because it's in conflict with what I put in the rental agreement? One, and then two.
Well, let's stop with
Okay.
number one. Let's fix that one first. What's
okay.
in the rental agreement?
Monday through Friday, 9 to 6, Saturday, 9 to 1.
I have no problem with that. You can augment the 3-day notice to indicate those hours.
Okay. And then secondly, I want to use the PO box under address to pay.
That
And
is also acceptable. The only
Okay.
thing with a PO box, you can certainly say on the 3-day notice, you can pay to the PO box, but then you don't need the times you have because obviously there is no time. The only
Right.
other problem with a PO box is that a person cannot deliver the payment to a PO box. There's only one way to deliver to a PO box, and that's to mail it. So at that situation, if they mail within the 3 days, whether it's received or not, it's on the landlord's responsibility. So you can't say, well, it didn't come timely, but it costs, as long as they're mailing it within the 3 days and they've complied with your notice. That's the only disadvantage of it's the only disadvantage of having it go to a PO box.
Okay, so as long as it's postmarked within the 3 days, it's acceptable.
Yes, ma'am.
Okay, and then lastly, okay, so because I have allowed, and now I'm regretting this, I've allowed Zoom payments after I served the 3-day notice.
You mean Zoom or Zelle?
I'm sorry, Zelle. And they try to pay partial payments. Can I return that money?
Yeah, so what Julie is talking about is that you serve a 3-day notice, you know you're not going to take a partial payment, but they electronically get that money into your bank account. So what do you do in that situation? And just as you're saying, Julia, you can certainly return the money. You can write your own personal check as soon as their check clears, and send it back with a note saying you've made an unauthorized deposit into my account.
Okay.
And by doing so, you will be able to return that money and proceed forward with your case.
Okay.
Anyway, thank you very much, Julia. I am going to say hello now to Fabiola Patron. Say hello and unmute yourself, please.
Hello, hi. Thank
Hi
you so
there.
much. Hi, Dennis. So my question is this. I have a client who has a triplex in the city of Los Angeles. She wants to sell the property. We're trying to sell the property. She inherited it. She doesn't have any rental agreements, very similar to somebody else's question earlier. No rental agreements on the property, nothing. And now the tenants have a lot of personal property, let's call it, junk everywhere. And it's making it very difficult to sell the home. Is there anything she can do?
It's difficult in that situation when you don't have a rental agreement. And it's just bad landlording at that point. You can tell the tenant to clean up the items that are strewn about the property in the common areas. And you can tell the tenant, if you don't, then I'm just going to toss it out myself. So you rented your unit, you didn't rent the common areas. I'm not allowing, even without a rental agreement, I'm not telling you can do anything to evict them, but what you can do is just tell them, look, clean it up, or I'm going to have somebody there just tossing this stuff away. And I don't see any problem with that. Give them a
Okay.
week or so to clean it up.
And then quickly, her goal is to sell it. So should she at this point try to get them to sign rental agreements? So that she has
Yeah, I
something
mean,
to
you can get
enforce?
them to try to sign them, but what if they don't is the problem, you know? You can't
Right.
force a tenant. What city is this, by the way?
Los Angeles.
Yeah, so you're under LA rent control, so there's very little that you can do at that point in time.
Wow. So she basically just has to try to sell it with the tenants and let the new buyer.
Right. I did want to make a comment, though. You have a beautiful living room, and I really like the artwork behind you.
Thank you. I wish it was real.
Oh, it's virtual?
Yes.
Oh my God, you little sneaky person, you.
Thank
Okay,
you.
well, that's it.
Thank
Anyway,
you.
nice talking with you.
You do.
Okay, we are going to move on to admin. Admin, obviously somebody involved in computers. Admin, if you would unmute yourself. Maybe not. Last chance, admin, please unmute yourself. Okay, then we're going to move on to, maybe he didn't want to talk, so I'm sorry that I picked on you. Let's move on to M. Brosar. I'm going to ask you to unmute yourself.
Okay.
Hello.
Hi, how are you?
I'm
Hi.
good, thank you.
Good, good. Thank you for the information. It's very helpful.
Yes.
We have a tenant that I'm about to, in a couple months, serve them a 60-day notice to move because I'm planning to move back into the property, a single property home. Is it wise for me to tell him ahead of time because he just had another baby, him and his wife, although they're on a month-to-month, is it wise for me to give him a heads up?
So you're planning on
Verbally?
moving in, correct?
Yes, sir.
What city is this?
This is in Silmar, California, San Fernando Valley,
Considered
Considered Los Angeles County.
LA County.
Well, Silmar is part of the city of Los Angeles.
Mhm.
Is this a single family home?
Yes, sir.
Only one house on the lot?
One house on the lot.
Okay, so you certainly have the right to do this, but the city is now requiring that we fill out an application process, file that with the city, and then pay them the relocation money, which is 1 month's rent.
Right.
So should you do this in advance? I would say, yeah. I would certainly tell them, look, we're going to be moving in, so I'm going to be serving you a 60-day notice in the future sometime, but I'm just giving you a heads up now. You might as well start looking now.
That's what
That's what we did.
That's what we did. I did that yesterday. My other question is, if he decides to move between the given date that I asked him, which is March of next year, do I still have to give him the 1 month rent?
And the answer is, unless you serve them with a 60-day notice, you have no obligation to do that.
Perfect. Great question. Thank you so much.
Thank you,
Anything
sir.
you want to ask?
No, the other question I wanted to ask, because this is a concern, they do have a dog that's on the property. That dog was in a car accident and they never took the dog to the vet. And the dog is in the backyard, basically suffering because it can't use its hind legs. Our exterminator, right, that comes and does the house regularly, he saw the dog and he loves animals. And he said, you know, I'm going to report this because he said, this is not
Animal
humane.
cruelty, right.
Animal cruelty. And he said, if they want, obviously they don't really care much about the dog, but they say they do, but they're just not taking care of it. And he said, I'm willing to adopt it and give it whatever rest of life it has, you know. Okay.
Yeah.
So
yeah, my bottom line, is there anything we could do? We report it to the animal control. They find them on $900, but the poor little animal is
It's
out
suffering.
there just.
Well, you have no power as an individual citizen to do anything other than what you've already done. And, you know, my heart goes out to you that you have that empathy towards animals. But the reality still is that you've done your job. It's not like you can go over there and start, you know, picking the dog up and taking care of it. But I really have to question, you know, what's going on in the head of your tenants. Anyway, we're going to move on.
Yeah, thank you
very much. And now we're going to go to Alejandra. Alejandra, please unmute yourself. Alejandra, it's right there in the center. You've got to click on where it says unmute. Okay, Alejandra, I'm going to move on. Thank you. Let's move on. Oh, are you still there?
Yes.
Oh, you just snuck in, Alejandra.
Uh,
Okay, so
I want to thank you for taking my call.
no problem. How can I help
have a
you?
tenant who is suing me in small claims court for their the deposit. They did not give me he asked me if he could leave early and not give me a 30-day, and I said okay. Then he overstayed and didn't pay and left without paying rent, and he didn't give me keys, but finally he left. Finally got into the property, working it, but I had the situation of I had to leave town for 6 weeks for a family situation out of state. And I asked him if I could not give him the 21-day thing that you have to give them. And he said yes. So he knew I was leaving for 6 weeks. I came back, and when I came back, obviously, first thing I had to do was get groceries. The next day, I had like a ton of things that people wanted.
I get
And
it, darling. You didn't
So-
send the security deposit itemization within the 21 days.
Correct. But
Okay.
he gave me permission.
Right, but did he do it in writing or a text or something?
No.
Okay, so, and now you've already got a small claims court. What you might want to do is I would go down to the same small claims court right now and file something called the defendant's claim. That's where you're going to sue him for all the rent that he owes you and all those items in the security deposit. So, and you'll serve him with that. So both cases will be heard at the same time in front of the same judge. And then you'll just explain to the judge, look, I was going out of time. I even asked him and he said what he said. So, and also, Your Honor, if you're going to give him back his security, well, then I have the right to ask for all the unpaid rent. And I'm doing it right now. So this should be a wash. So that's a good trick in small claims court to file a defendant's claim. So even if the judge says, yeah, you should have given him back the $2,000 security, and your position is, okay, yeah, I'll give it back to him right now, but why don't you rule on the fact that he owes me for all this rent owed another $2,000, so that basically washes itself out. And I think you'll have an easier time that way.
How about for the damages?
Well, again, you could sue him again in small claims court for the damages. So sue for rent owed and for the damages in that what we call the defendant's claim. It's kind of like a cross complaint to his action against you in small claims court.
Thank you very much.
You're welcome. Thank you for calling in. Let's move on to, I'm going to move on to Sonia. I'm going to ask you to unmute. Are you there, Sonia?
Shoot.
Hello, Sonia. Okay, I don't think you were ready to go. Are you ready? Okay, I'm going to mute you. Thank you. We're going to move on to Diane Delaney. I'm going to ask you to unmute. Diane.
Hello.
Hey there.
Hi, Dennis. Thank you for everything.
It looks like your cats are growing from last week.
I'm feeding them too much, apparently.
It appears so.
Dennis, you were talking at the beginning about possibly a voluntary agreement on a single family in city of LA. I have a situation where I have a tenant that we have a really beat up house, and we've just kind of let her live there because she's begged us and everything, really low rent, etc. Now she's come to me and she wants me to sign a document that she told me her new job is being foster parent to her 4 grandchildren. So I'm reluctant because the house is so beat up. I'm thinking, what is the liability? I just feel uncomfortable about it, but it just simply says, you know, it's just asking me if there's a rental agreement with this lady. But she has told me herself that she eventually, because I guess she's going to make quite a bit of money, or in her world, for the foster kids. What does a voluntary agreement look like? Is it different from that mandatory relo money, or what?
I'm not sure what you're talking about, a voluntary vacate. You said she wanted you to sign something. What is she trying to get you to sign?
Well, something for the foster parent program, just saying that that she has a rental agreement with us. There's nothing else in there. I mean, I don't know if I should go ahead and sign it.
The first thing that comes to mind, okay, is that if the house is not in good condition, then that's your responsibility to fix it. I understand there's economic issues dealing with that, but if you're renting out property, you got to make sure that that property is habitable and is up to code. This way you wouldn't have to get into this secondary question. I'm afraid of liability. Well, you know what? If the place is bad, then your tenant could fall down and they can sue you. So my first advice, I mean, is if you can't fix it, you don't have the wherewithal, or it's just too much of a task, then I suggest you sell the place. But otherwise, landlords need to keep their place habitable. I'm not telling you that you have to do cosmetic things, but at least make it habitable so that you don't get into these issues of these lawsuits. There's all these law firms that are going around and suing landlords for having inhabitable conditions. So I would certainly think about that, or thinking about getting rid of it. Should you have the kids come in? I mean, you don't have to sign it. She's asking you to, so there's no necessity to sign that. But I still think that since it's a single family home, maybe you could ask her for more rent and then use that money to fix the place.
Well, I mean, we actually would like to sell it. I mean, it's one because it's really, I mean, it's more like lot value. I mean, it truly is a very, very, very old home, and it's apparently habitable because the foster parent program came out and inspected it and said it is. I mean, to me, it's just awful, but it, I guess, meets the basic requirements. So I just didn't know what is, when I thought you said at the beginning that you could get a voluntary agreement between a tenant.
Well, you can. I mean, if the tenant, you can say to the person, hey, if you want to move and have these kids be raised in a better place, I'm willing to offer you some money to move. And you can offer anything from $1 to $100 million. And if whatever you two agree to, then we can do a voluntary vacate agreement for you. And then obviously you can get them to move, or you can say you're going to do some renovation to the house and ask her to move that way. Or you could just raise the rent, which is certainly your permission. But I think it's probably better to talk to the tenant, tell them you're planning on putting it up for sale. You're going to need to get them out anyway. So therefore you don't want to sign any agreement to have additional people moving in. And why don't you see if you can come to terms with her for her to move to a different place?
Okay, that sounds good. Thank you, Dennis.
All right,
Enjoy
thank
the
you.
game.
And if you would mute yourself, and we're going to move on. I think our last caller, based on the fact that I got somebody waiting for me in about 10 minutes, I'm going to go to, let's see, this is the real estate rappers. Real estate rappers, please unmute yourself.
I really thought I wasn't going to get on today, so thank you, Dennis.
No problem.
I'm a realtor, and I have a couple of investors that have bought quite a few apartment buildings, which they haven't been able to raise the rent and do some, you know, with everything that's going. They're all in Inglewood, and when someone didn't pay, you know, and the housing authority there is way out there. I mean, they throw it back in your face. As you had said a few weeks ago about the increase of rent, that if we have to have them all out by December 15th, correct?
Well, you can do it a little bit later. It has to be about 35 days.
Right. And if we want to go up for February 1st, you said that our best bet
Yeah,
is
I
to
would
get
serve it
everything
on
out.
December 15th, correct.
And is that mostly everything in LA City? I mean, I know, I mean, LA County, like if it's Paramount.
No, that's only LA City, only LA City.
Okay, so Inglewood would, so is that different for Inglewood?
Well,
that's county,
yeah,
right?
Inglewood has their own statute. I'm not sure what the rent increase is for Inglewood right now. It might be 3%. You can do that immediately.
It says on the site 3.8.
Yeah, well, there's if you're under statewide rent control, it's 8.8%. Okay. And in any event, my mystery base just came, so I'm going to mute you. And I want to at least introduce my mystery guest, whose name is Ryan Block. And I happen to know him very well. I'm going to ask you to unmute yourself.
Hey, how's it going?
It's going very good. Just I want to introduce everybody. This is my son, Ryan Block. He, believe it or not, is also an attorney. He has a wonderful firm that's located in the same building that I am. It's called Block LLP. He does personal injury, but he also does, which is unfortunate, which I kind of touched on today, he also does represents landlords who are getting sued for habitability. And so why don't you speak a little bit about how landlords are getting sued these days and what you think landlords can do to protect themselves?
Sure. So, you know, a lot of these cases that we're getting in is definitely going to be habitability, tenant harassment ordinance, retaliation, discrimination cases. And basically, most of the time, the landlord just kind of ignores some of the issues that are going on in the unit. And I would say the best way to combat that is just immediately addressing those issues, getting the handyman or specialist out there right away, especially if it's a big issue. You want to get the problem fixed. And, you know, a lot of times you're going to have your tenants, they might just pretend that something was fixed when it wasn't. Or the other way around, they might say that, hey, this issue was not fixed when it was. So you want to make sure that you confirm with the tenant, you know, get them to acknowledge in text, hey, this issue is fixed. But more than that, you also want to go to the property regularly and do inspections and just make sure everything looks good, because you as a landlord have a duty to inspect the premises. I would say every 6 months is a pretty good idea. So I would recommend doing that.
And what are you seeing in terms of these types of lawsuits? How much are these landlords getting sued for?
You know, even a basic habitability case, you know, you're looking at $250,000 for something stupid. So, I mean, whether the case is actually worth that or not is obviously a different story, but that's what they're suing for. You know, a lot of people, you know, they come to us and they say, oh, I'm going to get my insurance involved, this and that. Well, the problem with that is yes, insurance might cover it sometimes, but if you're not represented by an attorney, they'll try to deny coverage for little things when really you should have had coverage. So it's important to have an attorney on board right away, so that they can help protect you, not only to defend you in the action, but also to make sure that the insurance company does their job correctly and gives you coverage for those kinds of claims. So once a lot of times we get a denial of insurance coverage undone, and we get coverage for the client. And then once we do that, we also submit our bill to the insurance to reimburse our clients for all the fees that we built, because that's also appropriate. So it's just very important to get someone on board right away for these kinds of claims.
And Ryan, why don't you tell everybody your phone number, which when we do the, I'll have this when we do the editing and put this up on YouTube, I'll have your phone number imposed. But what is it for anybody listening right now?
Well, our office number is 818-714-0655, and our firm is called Block LLP. We have a website, you can go onto it. It's blockllp.com. And we'll take care of you. We're happy to answer any questions, even if it's just free consult, that sort of thing.
Well, thank you very much. I know me and you are going to a Laker game, so we got to get our butts out of the house. I want to thank everybody. I'm going to try to do next week's show from Las Vegas, and I appreciate everybody joining in on us today. Thank you so much.